defendant's view, and that's going to really go to creating this issue of reasonable doubt.
Now, for a defense attorney, basically they want to poke holes through. You said something about a chain last week.
Right, I was. In fact, I was just going to say it again.
Well, I'm just reminding you.
You're reading my mind, Gary.
Excuse me, I'm sorry.
We're doing this
I'm
long
clairvoyant.
enough. You're doing this long enough with me now. You can almost tell me what I'm going to say. It's like my wife. My wife says, "You're feeling such and such." I said, "Well, how do you know what I'm feeling?"
No, I'm just helping you.
That's the way. That's the way it works.
All right, thank you.
And so, you're right about the chain.
We're
going to talk about things called circumstantial evidence. Now, people have heard that term many, many times. What is circumstantial evidence? I'm going to tell you what circumstantial evidence is. There's a difference between circumstantial evidence and direct evidence. Direct evidence is what you actually physically see. Circumstantial evidence depends on an inference that is drawn from a fact. Now, we used the example last week, and we'll use the same example. The kid is in bed. You go into his bedroom and you see he's got jam all over his lips. And then you go down to the kitchen and you open up the refrigerator and you see there's a jam jar. It's opened and there's a little bit of a fingerprint on the door handle. Well, you are to infer, of course, that because you go to the refrigerator and you see what you see, and the kid's got the jam on his lips, that's the inference that you draw that he's the one that took it. And so it's like a chain. Here we get into your analogy.
Circumstantial evidence.
Yes.
Thank you.
Every piece of circumstantial evidence is like a link in a chain. And if you break a link and you're wrong, you're done. Well, not necessarily, but it affects the credibility of the rest of the evidence. And what you want to do as a defense lawyer in a criminal case is you want to break that chain open as many times as you can to show that the inference that you're drawing isn't the one that the prosecution wants to do. And I'm going to give you some examples in this case. And by the way, I'm sitting here looking at Carl Evans, who's a guest here today. Carl is a well-known, established motion picture director and
a friend of mine.
Yes.
That's why he's here.
I think we are.
Yeah, of course we are.
Okay.
He said you were.
Absolutely.
He said when he told me when he told me he wanted you to invite you here today. He said he's a cool dude.
He is a cool
I
dude,
may
right?
be old, but I still use the word dude.
All right, he is a cool dude, right? I mean, come on.
Look, he's from New York.
There you go.
How bad can he be?
Yeah, right?
No comment. I worked for a guy in New York.
I know you worked for a guy in New York. He was a real New Yorker too.
Some of them aren't great. I'll give you that. But that's anywhere.
Look, it's a whole different lifestyle. My son lives in New York, and he moved there because he went to medical school there, and he stayed. And I say to him when he comes to visit us, and it's so beautiful here and sunny and warm, and there got 8 degrees in Manhattan. I say, "Okay, how do you not miss this place?" He loves New York. That's what it is. We'll talk more about it. We're going to get into the case right after the break.
All right, it is for the people of Judge Herb Dodell. And if you want to get his book, From the Trench to the Bench, hit it up on Amazon.com. We'll be back with the judge right after this.
1050 AM, KCAA.
Herb Dodell is a lawyer and a judge for the people. Having served as a Superior Court judge, presiding over more than 9,000 cases, he has witnessed firsthand how complicated and corrupt the legal system can be. His goal is to show how things really work in the legal system so that people can navigate the legal system in the best way for them. Many people often feel marginalized by the legal system and are uninformed about how to proceed when unfortunate circumstances arise in their life. Judge Herb will pull back the curtain, lift the veil, so people can truly understand their rights, have access to top legal personnel that they can trust, and have knowledge about how things work so they can make better choices. Judge Herb isn't just knowledgeable. His integrity and spiritual values are truly what make him different. He cares about democratizing access and information for all and desires to turn on the light so the people, you, can benefit. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Okay, we're back. So before we get into the facts of the case, and I make a decision whether or not to ask the questions to Carl or Gary.
Oh, I'm not answering them anymore. I'm done.
You taking the fifth?
I'm taking I plead the fifth.
By the way, I'd like to throw in a little news here and there too. People think about the Fifth Amendment because it's obviously very prominent in the news today, and we've been mixing up some of the shows talking about actually rules of evidence and procedures as well.
Yep.
Can you take the Fifth Amendment in a civil case? What do you think, Gary?
I think it was no.
Yes, you can.
Okay, there you go. I was wrong.
I'm going to say yes.
Nice, Carl.
Why? You want to know why?
Yes. Well, actually, I do want to know why.
Because as long as you're under the threat of being prosecuted.
Oh, you didn't say that to me.
Okay. Well,
you just said civil. You didn't say he was under a criminal investigation.
no, it may not be a criminal investigation, but there may be, depending on what you have to say. And so you don't want to give up any information you can to the prosecutor. It's never a good idea, unless you're pretty close to making a deal. It's never a good idea to talk to the prosecutor without your lawyer being present. Why? Because you're going to say one thing one time. You might talk to another officer another time and say something different. The next thing you know, you've got 3 or 4 inconsistencies, and that goes to bury you because you don't testify at the time of trial, and you don't have to testify at the time of trial in a criminal case. It may come back to bite you. So you don't do that. So you can take the fifth if you think that there's even a possibility that you might be prosecuted down the road. But you don't have to be necessarily prosecuted as a main defendant. You could be, as some people may very well find themselves in this travesty that's going on right now, you may find yourself as an unindicted co-conspirator, which is a definite possibility. And you don't want to give anybody statements. In fact, people always say to me, if you were President Trump's lawyer, would you let him give a statement to Mueller? I didn't even have to think about that one. The answer is 100% no. No possible chance that I would ever let him give a statement.
Even if you scripted it for him? Even if you actually showed him what to say and you walked him through it and you rehearsed it?
Probably not.
No?
No, because what happens, many witnesses are not capable. I'm not talking about the president now. Many witnesses are not capable of just answering a question yes or no. They got to explain everything. And they volunteer. And so they go off script.
Mm.
There really is no script because one of the things that happens in law enforcement, and I was trained when I was a deputy DA, you learn how to interview. And you ask certain questions that you're encouraging people to volunteer something. And from that, you take it to the next stop, and pretty soon you're way off the script, and they're not prepared. And one of the things about the law, if I were to ask you the question, can cops lie to you if they're interviewing you? Can they lie to you? Can they say, you know, your partner's in the next room and they just confessed?
Yes, they can say that.
They can lie to you.
Yeah.
And they do.
Yeah.
That's part of the training.
To trick you.
Yes, that's right.
To change your story.
Absolutely right.
Yeah.
Judge, I think we got
or to get you to flip.
I think we have a caller.
Okay.
You want to take a caller?
Sure, why not?
I think we do. Caller, are you there?
Yes, I am. Fred Plumley here.
Hello, Fred.
Hello.
How can I help
Judge
you?
Dodell, how are you?
I'm good. How can I help you?
Well, you know, the reason I'm calling is I work at KCAA, do marketing, and have a show that I've had for 10 years, but I have a good friend who was basically accused of this woman of assault, and I guess what happened is they had some kind of dispute, and maybe he was going to leave her or something. So what happened is she hurt herself, you know, punched herself or made it look, and then called the police, and my friend was arrested.
She punched herself, huh? How'd she do
Yeah,
that?
hurt herself.
Is there any medical evidence to support that?
You know, I don't know all the details, but I do know that, you know, this is a good friend of mine who's a very nice guy. I've known him for years. He's very mild-mannered. I've met, you know, the girlfriend as well, and I am certain that he's being really honest.
So what's the question?
Well, the question is what does somebody do in this kind of case, and what's the best way for somebody to fight this, especially if they're innocent. What happened in this case is, he got arrested. He ended up spending a couple weeks in jail, believe it or not. And
why is
he
that?
was innocent.
Why didn't he make bail?
I don't know. I guess he could have made the bail.
Well, bail, especially in the old rules, depended on the nature of the offense as well as some other considerations. You're talking about an assault case with probably minimal injuries. Bail's not going to be that high. In fact, in many cases, bail wouldn't even be an issue because the judges basically look to see whether or not you're a threat to the community or whether you're a flight risk. Those are usually the criteria that are being used, as well as the seriousness of the crime. So he's been charged with an assault. Is that a criminal charge, or he just got sued for assault?
No, he's getting off the felony.
Okay, so a felony. Okay, so it's assault and battery, right?
Yes.
Battery is touching. Assault is no touching. You understand that? The difference? You can have an assault without it being touched, as long as you're fearful or you're apprehensive reasonably that something is going to happen.
Hold on. So you can file an assault charge even if you don't touch the person?
Sure.
Really?
Yeah.
You feel like your life is threatened, something
Yeah.
like that?
I mean, even
Absolutely.
if you don't
That's an assault.
even though you don't have a weapon or anything?
Yeah, it's an assault. Well, it goes to the degree of the seriousness of it.
That's pretty
tricky. Somebody yelling and screaming at you, it could be very well considered an assault, depending on the circumstances.
Really?
But then again, you get into the argument of First Amendment, yelling and screaming at somebody, and even getting to the point of quasi-threatening may not rise to the level of assault. A battery is a little different. Battery requires a touching of some kind.
Can I ask a question? Was there any bruises on this woman, or did she go to the hospital because of these injuries?
Well, I don't know all the details, but I think what happened is she hurt herself significantly to, get, my friend arrested. So I would assume that there was evidence of that.
Let me tell you, Fred, one of the biggest problems that people have is they assume. You don't have enough facts for anybody to give you a reasonable opinion. There are too many questions that I would want to have answered before I could even tell you where you're going. Was this in a marital situation or a relationship situation? Because then you get into the question of domestic violence. There may not be that if they're not. You could be living with somebody and that qualifies as domestic violence. You don't have to be married. So yeah, I need to know a little bit about
They were boyfriend and girlfriend. I'm pretty certain they were boyfriend and girlfriend.
Well, the boyfriend and girlfriend doesn't count. It's got to be, were they cohabiting? Were they living together?
I believe so.
Believe so. Well,
Okay, they were living together.
I'm pretty
okay, let's
certain.
assume that. Let's assume that because this is going to be an intellectual question, and we can't take too much time because we got a case that we have to talk about on the show today. But the fact of the matter is, if they were living together, that qualifies as domestic violence. That's a civil matter, but there's criminal domestic violence as well. So you have to get into the details as to what happened. Punching oneself sounds like a hard sell to me. But then again, there are forensics that can be done to make that determination. The angle of the blow, where it was, the direction in which it's coming. It's like the cases involving guns. You look at to see with the bullet trajectory and things like that. So I don't have enough information to do anything about it, but he's obviously has to defend himself against a felony.
Well, yeah. Let me ask you, Judge. What would you recommend this person to do? Just get the police report first, and then get a lawyer?
Well, what happens chronologically? Is you should get a lawyer right away, especially for felony. You get a lawyer right away, and when you go to an arraignment is nothing more than asking you whether you plead guilty or not guilty, and basically setting some dates and waiving your constitutional rights to read complaints and technical things, not significant. And at that point, the prosecution must give you what's called discovery, whatever they have. If they have any police reports, if they have any medical records, they have any eyeball witnesses, they need to tell you that so that you're not blindsided later on and surprised by something you didn't know about. And then you have to prepare, usually in preliminary hearings, there's two ways to go about it. One is called a preliminary hearing, which is like a mini trial, and the prosecution puts on a bare bones case to show that a crime has been committed, whatever that crime is, and it is a reasonable belief that the person who is being charged with the crime is the one who committed the crime. A lot of crimes are based on, whether it's hearsay or it's based on outside extraneous facts. I mean, you need to know that. And you get into the question of circumstantial evidence and how far will it go. Assuming that the prosecution proves there's reasonable basis to believe those two elements, they're held to answer. Held to answer means there's going to be a trial. At some point, there's a trial. There really is no discovery in a criminal case, so you don't take depositions and you don't do things that are involved in a civil case, although there are some exceptions. Smart criminal lawyers use these procedures. One is called a demurrer to the criminal complaint, where you are able, under certain circumstances, to take the deposition or testimony of witnesses. That's usually not done in criminal cases.
Let me ask a question, Judge. Is there any way to cut a deal on this? I mean, it sounds like it's
Sure.
It's sort of like a weird dynamic here. Not sure if she injured herself, and that's what he's stating. I mean, I'm sure there would be some sort of evidence on this. Wouldn't you you always say cut a deal. Wouldn't you try to cut a deal here?
Well, you have to look at a lot of factors before you make a plea bargain. The people may want you to plead to a felony, and if you think the case is weak, why would you want to plead to a felony?
No, I'm just saying.
Felony
you
means you'd end up in state prison.
Yeah, well, that'd be stupid.
And on the other hand, sometimes the prosecution, I've had cases, even when I was a DA, where we dismissed it halfway through because it just didn't seem to hold up. You don't want to take a case to the end if you're going to lose it, and you're not going to prove it beyond a reasonable doubt, because politics are politics everywhere. You lose a lot of cases as a deputy DA, you're going to end up in traffic court. You win the big ones, you're going to end up with the big cases. So everybody wants to check the record of how well you're doing. It's controlled chaos.
It is.
I'm just curious, where is it right now as far as this case is concerned for the caller?
Previous to the preliminary hearing, after the arraignment
Hold
and
on.
some discovery.
Has he been? He hasn't been arraigned yet, then, has he?
Yeah, he's been arraigned.
Oh,
I think that he's been arraigned. And I think I get from you, Judge, that it's probably be very important for him to have a very competent and well-known attorney in the court, right?
Well, first of all, if he didn't make bail, the chances are he isn't going to be able to afford a top-of-the-line lawyer, and he probably qualifies for the public defender. Now, there are some very, very good public defenders, but they're overworked, they're overwhelmed, and they don't have the time, generally, to devote to a lot of these cases. And so you get good lawyers, but you also get a lot of brand new lawyers that are just getting experience. They're going to work in the public defender's office for 2-3 years, and then they're going to go out on their own. So who you get, it depends on your financial capability. So it's good talking to you, Fred. I can't give you any more information because I don't know enough, but I'm happy to. If you get more information, get in touch with us, and I'll try to give you some guidance. Okay?
Well, thank you very much. I want to let you know I really enjoy your show, and I know everybody loves it. Great information. Thank you.
Okay, we'll talk to you again then. Bye-bye now. Okay, so let's get back to our case now.
Well, we got to take a break.
Okay.
And then you can get back to your case.
That took like about 15 minutes.
Overruled. All right, we got to go. It's From the Trench to the Bench. We'll be back right after this with, For the People. This is the books From the Trench to the Bench.
And the case is called You Be the Judge.
You Be the Judge.
10:50 a.m. KCAA.
In his book, From the Trench to the Bench, Judge Herb Dodell demystifies the legal system, including both civil and criminal, the lawyers, the judges, and the process. As a judge, former deputy district attorney, and criminal defense attorney, he knows the legal system. He has the inside information that you need to pick a lawyer, and he's here to give it to you. No matter what you're facing that makes you think you may need a lawyer, Judge Herb will shed valuable light on your situation and reveal your best options and many secrets of how the judicial system actually works. To find out more about how the legal system really works, you can get your copy of Judge Herb Dodell's eye-opening book, From the Trench to the Bench, at Amazon.com.
Okay, we're back. So, one of the things that I just got out of that conversation with Fred is that many people ask you questions and ask you for advice, but they don't have enough information to give you so that you can give them any advice. So my word of advice to all of you who have these situations is, one, write down everything and make sure you make inquiries about what is significant in the case so that you can tell the lawyer what you know. Otherwise, you're leaving somebody out there guessing. And there's no room for guessing in this business. We don't guess. Not generally. I mean, you take crapshoots with picking juries and things like that. That's a guess too. And if anybody tells you there's a way to pick a jury and you're gonna get the right one, there's no way to get.
Always
know in advance.
Always have paperwork, right? That's what my dad told me. He said, document everything in a civil or criminal case. Document everything and write dates down and everything, right?
Okay, so here's the case. Dr. Jackson was partners with Dr. Phillips, also a physician. And they had an office that they shared, and they were also lovers. Neither was married at the time, but they were also working together as well as being lovers.
Man and woman.
Man and woman.
Okay, just want to make sure,
That's good.
All right, just, it's that time of, it's,
Yeah, okay.
You never know.
you never know
You
anymore.
just never know.
If I said it was Bill and Tom, would it make any difference?
No, but I'm
No.
just pointing it out.
Okay, but it's not. It's Dr. Jackson and Dr. Phillips, and she owned the building where the medical practice was, and it was her medical practice that he went into. So in 2012, there was a water loss. In other words, a toilet exploded or was overflowed and it caused serious damage. She was the policyholder. So she made the claim with the insurance company, the first insurance company, and they thought it was suspicious, but they paid it. Then they started to get a little dicey with the two people together. And in 2013, there was a burglary. And the burglary resulted in the taking of furniture, computers, and things of that nature that really belonged originally to the practice. This was after the parties were starting to get unhappy with each other, and he bought the business from her. And he bought the building because she had defaulted on the mortgage, and he bought the building too. So now he had the building and he had the business. And she wasn't doing very well. Myriad number of mental issues. And so they had this burglary.
Can I ask you a question? Were they documented mental issues?
Yeah, she actually went to a mental facility one time.
All right. Okay.
And she had been sued by many, many, many people as well.
Okay.
So, well, thanks for asking the question, Karen. That's good, nice information. So the claim is made, and the insurance company pays the claim. Now they're in a real battle. She sues him for basically wrongful termination. They're not happy with each other by this time. Comes now January of 2014. There's another water damage loss, which causes significant damage to the building. By now, he's the policyholder because now his building and it's his business. Makes a claim, and he hires a public insurance adjuster. Public insurance adjuster works for the insured in dealing with the insurance company. His name was Bates, and he goes out and he gets a contractor. The contractor, whose name is Jones, comes on the scene, and they're going to fix the damage for the water loss. And it turns out that this water loss was caused by somebody messing with what's called the flapper, not the flipper, the flapper, and stuck a lot of paper in the toilet, and it overflowed.
Hate that.
That's what happened in that water loss. So now you have the contractor, you've got the public adjuster, and you got Dr. Jackson making a claim. In the meanwhile, Dr. Phillips had sued Dr. Jackson, and on a particular day in March of 2014, she lost. She lost a significant motion. That very 2 days before that, there was another burglary, another break-in. A window was broken. Somebody got in. It was a minor burglary, but there was another burglary, followed 2 days later by an arson fire, which burned the building down. And there was a video. The video showed somebody in a car getting out of the car, going toward the building, and then you see on the video somebody coming back, and that's about the time that the fire started. And an insurance claim was made, again, to the new insurance company, which had come in for the first water loss. And the insurance company didn't want to pay because it was an arson fire. And they didn't do anything about it. They negotiated with the public insurance adjuster and ultimately paid about $600,000 out for the water loss and for the fire loss. About a year later, an employee, supposedly an employee of the contractor, Jones, was arrested for the arson, claiming that he conspired with the construction company owner and the public adjuster and Dr. Jackson to burn the building down, to make these losses, to collect the insurance proceeds. And about 3 years later, Dr. Jackson is arrested and is charged with insurance fraud and for the arson, conspiring to commit arson.
That's a big deal.
That's the people's case.
Wow.
They also claim that there were cell phone records that shows that the contractor and the adjuster and Dr. Jackson had had some conversations, phone conversations, on the day of the fire and after the fire. They also claim that Dr. Jackson was in bad financial condition. He hadn't paid his taxes, and he had allowed the business license to expire, and business wasn't doing very well, and he was trying to sell it. And that's, they say, evidences a conspiracy among the parties. The contractor was going to get the job to do the repairs, get paid by the insurance company. The employee did what he was supposed to do. The public adjuster was getting a fee, and Dr. Jackson would be pulled out of the financial hole. And so they all conspired together. There's no documents, there's no records showing there was any kind of an agreement. And the legal term is called conspiracy. Now, the rules of evidence we're going to talk about in this case, and then I'm going to tell you what the defense side is. You shouldn't make your own mind up based on what you hear from one side. Although, as I mentioned previously, there was a study done at the University of Chicago many years ago that said that 90% of the juries made up their mind right after the opening statements. So what I've basically given you now is an opening statement. Ladies and gentlemen, the evidence is going to prove and all the things I just told you. And so each of these elements is an element of circumstantial evidence because they have no actual physical proof. And now the issues of evidence that you're going to have to decide, because you're going to decide whether I should sustain or I should overrule the objections. The first objection is going to be that they want to bring in all these prior events, claiming that because there were prior water losses and prior burglary and everything else, that means that he set this fire also, because that's his character. Now, in California, there's a rule, Section 1101 A and B of the Evidence Code, that says you cannot use character evidence to prove that somebody did something on a subsequent occasion because they previously had done so in the past. That's the first objection that's going to be made when the people offer this as evidence. The second objection is going to deal with the tax records. Their prosecution argument is that the tax records, or the failure to pay the taxes on time, is evidence that he was in bad financial condition, and so they want to introduce that evidence as well. And the argument that's going to be made, the objection, is that it's not relevant. It's called a 352 objection. And the third will be the public adjuster made notes. He will show that he didn't meet the contractor or the insured, Dr. Jackson, until after the water loss in 2014. So how could he have conspired with him? He didn't even know him. And he had a document indicating that he went to the first interview on January 7th, the day after the water damage. So the argument is going to be made by the prosecution that that should not come into evidence because it's hearsay. It's an out-of-court statement being offered for the truth of the matter, and that's the definition, the basic definition of hearsay. And so that's going to be the third evidentiary objection. Now you'll have those three decisions to make: sustain or overrule each of these objections. Now here's the defense side. Defense side is Dr. Jackson would say, if he was to testify, he would say that in 2012 he had nothing to do with the water loss. He wasn't the policyholder. He got nothing. All the money went to Dr. Phillips. That the burglary that took place in 2013 was a burglary that she committed herself, because it turns out that all the furniture and computers that were stolen ended up in her new medical practice in Southgate. And there's witnesses to prove that. So whatever was burglarized wasn't burglarized by him. She set it up by herself. She also lost a serious motion after she had sued him, and they were pretty angry at each other, no greater fury than doth the woman scorned. And the water damage loss,
We know.
the same thing with the water damage loss. He said, Dr. Jackson says, I have no idea. Why would I want to flood my place? And I didn't know any of these other people, the contractor, the public adjuster, or I never even met the employee. And it turns out he's not an employee. He's an outside independent contractor that happened to be working on the job, so he had no actual interest in the outcome. As far as the taxes were concerned, he had an agreement with the mortgage company that they were going to pay the taxes as part of an impound account. And the mortgage company screwed up, and there's records showing that they had failed to pay the taxes. Ultimately, he paid them on his own. And that's going to be one of the objections you're going to hear about that. And that as far as the fire is concerned, he had nothing to do with the fire. He was somewhere else. He didn't hire anybody. And as far as he's concerned, that video shows that it was taken an hour before the actual event took place. Somehow the camera wasn't on or whatever it was, and that the person who set that fire was probably Dr. Phillips. She was angry. She just lost a big motion against him. She was trying to prevent him from selling the property. And it's coincidental that the fire took place the same day, and there's evidence with court records showing that she had lost that, and she ultimately lost the case. So he says the insurance company is behind all of this because they're trying to get their money back, and the evidence will show that in the insurance company records they were talking about how they're going to get their money back. Now, if it's Dr. Jackson, they get their money back. If it's Dr. Phillips, they don't, because she's not the policyholder. So part of the argument to be made by the defense is that this was done by Dr. Jackson, the insurance company jumped into it, and therefore he should be found not guilty. And that's basically the opening statement that's being offered by the defendants. We coming up to a break?
Yes, we are.
Okay, so think about it for the period of the break. I'm going to ask you about the three rulings, and then we're going to determine whether or not he's guilty or not.
Radio, 1050 AM, KCAA.
Did you ever meet a lawyer that was for the people? Someone who had the best interests of the people at heart? Herb Dodell has been a lawyer for more than 50 years and has been a Superior Court judge for 9 years, having presided over more than 9,000 cases. In this show, he will reveal the secrets of how things really work in the legal system, so you can maximize your position and benefit most when you're in trouble and need someone on your side to simplify the process for you. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Okay, so we've had a little off-the-record saying off the record. It's kind of like a common thing I always say. There's no record. Well, yes, there is a record. But we have Carl here, who's a disinterested party who didn't hear last week, but he heard all the facts this week. So let's go take the objections first, because we have a limited amount of time. The first objection is the prosecution wants to offer in evidence the fact that there was a prior water loss, a prior burglary, and another water loss, and therefore, because there was a conspiracy to do all these things among Dr. Jackson and these others, that should get into evidence. The objection is that it's character evidence, it should not be admitted. Do I overrule the objection or do I sustain it? Go
Don't look at me. Don't look at me.
last
I
week.
voted
Well, I
last week.
think
I'm not doing it.
you're gonna overrule it.
I'm gonna overrule it.
You are.
Yeah. The reason
Why?
being because there are exceptions to that rule, by the way. One of the exceptions is called common scheme and plan. Common scheme and plan, if you could show that this person has done the same thing a couple of times, and that's what his general modus operandi is, it comes in. But you still have to meet what they call foundational requirements. In this case, there are so many issues as to whether or not he knew anybody, he had any involvement with these people. They're talking about a conspiracy which is not supported by any evidence other than by surmise, and therefore, and it's extremely prejudicial to Dr. Jackson, who would have to put on this evidence to refute it. So I would overrule the objection on the grounds that it didn't meet the foundational requirements. That's number one. Number two, with regard to the taxes, the prosecution wants to say that the taxes weren't paid, and therefore that's evidence of his financial difficulties, and that was the motivation behind all of this conspiracy. In or out? Overrule it or sustain it?
Well, that's good.
Carl's
No, that's good. That's what we're supposed to be doing.
Yeah,
I know the
well,
answer.
Yeah, right.
You
I
were
don't-
here last week. It's not fair.
Yeah, you already heard this whole thing.
Well, I already went through it.
I know
went
you
through
did.
the same
I know
thing.
you did. I mean, it's tricky when I think about it, because if the facts are that he had a deal and the deal was set up that the taxes were going to be paid, whatever evidence they have, if that evidence is there and it's shown, then it diffuses that concept. So whatever side you're on, it depends on what you're going to do. Are you going to let it in? That's the question. Are you going to allow it?
That is the question.
Yeah.
Now, there's a question in every case dealing with something called relevance. The relevance that the prosecution is saying is that this is evidence of a financial difficulty, whatever the other facts that the defense wants to add. The defense is saying, look, it's prejudicial, it's time-consuming. I'd have to bring in the people from the mortgage company, and that it's going to take a particular period of time to take, and obviously it's prejudicial. What do you think my ruling is?
You're going to let it in?
I am going to let it in.
Okay. I'm 2 for 2 right now.
Yeah, you are.
All
Let's
right.
see how you do.
All right,
on the
well,
third.
so was I.
It's 50-50.
Let's see. Let's say you do another.
All right.
Why am I letting it in? Because it's relevance. It's up to the jury to decide whether or not they're going to give credibility to the defendant's argument that it was being done by the mortgage company. Maybe they'll bring in somebody from the mortgage company that says that's not true. It's relevant enough.
You got to get to the bottom of it.
And even though it's prejudicial, and even though it may take some time, you generally err on allowing relevant testimony. So I would have overruled the objection, and I'd let it in. The third is the notes made by the public adjuster Bates. He wrote these notes on a particular day. It was his custom and practice to write those notes whenever he was on a job. Do I let it in? Or do I deal with the hearsay objection because it's an out-of-court statement being offered for the truth of the matter, that he was someplace at a particular date and a particular time, and it's in a document? Do I let it in? Or do I overrule the objection, or do I sustain the objection? No coaching, Gary.
I'm not saying a word.
He's not slipping me any notes. So
I'm
that's
watching
good.
body language.
I'm not doing anything. I'm sitting there drinking a beer.
You know what? I'm thinking that you are not going to let it in.
Okay, I am going to let it in.
Okay, good. I want to know why now, because I'm
Okay,
wrong.
because the objection is it's hearsay, as I just mentioned,
Right.
right? There's an exception to the hearsay rule called the business records exception. I didn't tell you that. I probably should have. And then before we
Well, then that's the reason. I didn't get
It is
it.
It's the
the
judge's fault.
No, no,
I
no.
probably should have told you. But
Okay.
the bottom line is there's an exception to the hearsay rule that allows for a document if it's made at or about the time of the event by a person who would normally make notes like that at the time of the event, and it was true at the time of the event, and that's the custodian of that document, and you can authenticate that document, it comes in as an exception to the hearsay rule. So it gets in to show that neither the adjuster nor the contractor nor Dr. Jackson knew each other prior to the time of this water loss. And if they didn't know each other, it'd be pretty hard to prove a conspiracy among people who didn't know each other.
Right, of course.
And so that's a significant argument as to its relevance, although the evidentiary objection wasn't based on relevance. It was based basically on a hearsay.
I have a question.
Go ahead.
Is that like the Comey notes?
I don't know enough about the Comey notes, but I think that's probably true.
Okay.
He made notes.
Always after his meetings.
Yeah, I would think it's
Like
it's
a
probably
like a ritual. Yeah, he was.
it's probably well, it certainly is relevant.
Okay.
And if the president said it didn't happen, it would come in as another. It'd be something called an inconsistent statement. Might even come in kind of under some of the other exceptions. There are about, I think, 11 exceptions to the hearsay rule, one of which is called an admission. If a statement is made, and we talked about if somebody's lying on the ground and they're dying, it was just in an automobile accident, and they said, oh, they passed a red light. Well, that's obviously hearsay, but it's called a dying declaration. It comes in because it's deemed to be trustworthy. And so there are, the same thing is, oh, I just saw them pass the red light. Well, that comes in too as an explanation. Is called something the res gestae, the actual act. People say those things when things are happening. And so therefore it's a greater reliability or greater truthfulness to the actual event.
Would that statement have to happen right away? Or?
Contemporaneously. Has to be at the same time.
Okay.
Now we're going to get to the final part, which we didn't do last week.
Oh, cool. I can participate
Now we're
again?
in fact, we're going to let both of you decide.
Oh, goody.
Right.
Hey,
Right.
two of you
Look
are
at
going to get guilty or not guilty based on what you heard. Only what you heard, and you know what's getting into evidence and what's not getting
Okay.
in. What's your decision, Carl?
About the
Guilty or not guilty?
not guilty.
Why?
There's too many things that made me realize why would you risk being caught lying based on the facts, the not knowing the people, not getting the money from the water damage, having the business, and potentially showing that the taxes were paid by the building versus the individual who could have done this crime. To me, it just doesn't add up. It doesn't make logical sense, and it doesn't seem like a smart thing to do. So I think that he probably didn't do it.
But you say probably.
Well,
remember, the burden of proof is beyond a
All
reasonable
right, so
doubt.
yeah, I definitely didn't do it. I'm going to change my
Okay,
answer.
Gary, you didn't vote last week. You got to vote this week.
Well, I say not guilty, just
Why
because
is
of
that?
the lack of evidence, lack of consistent evidence. Too many statements were construed. The woman was a nutcase. I mean, she had been in a unstable mental condition. Her furniture arrived at her office. The taxes, the guy said he paid the taxes, when he didn't have to pay the taxes. So there were just too many inconsistencies.
But then, and then I was glad you brought that up. He also ended up paying the taxes, though. He was
He did.
able to pay them.
Yeah.
Yeah.
So then there's the thing where I know financially is an issue, but if there's such an issue, how's he paying the taxes?
Exactly.
So that makes me think, well, I guess he's not that bad off if he can still pull the taxes.
Yeah, if he's paying if he already paid the taxes when he didn't supposedly need to.
It's the property taxes, by the way.
Right, exactly.
Yeah,
I mean, they're heavy duty taxes.
They're steep.
Yeah. I mean,
For a building, absolutely.
So all those inconsistencies.
Beyond a reasonable doubt. Remember that.
Beyond a reasonable
I
doubt,
said
for
beyond
sure.
a reasonable doubt.
I don't-
I definitely feel that way.
I don't know if he's
Absolutely.
innocent, but it's beyond the reasonable doubt.
He doesn't have to be innocent.
I know, that's what I'm saying. I mean, in a civil court, he could still be sued, for damages or whatever by the insurance company.
And by the way,
he
there
was.
there is a civil lawsuit.
There is. Of course there is. Of course there is.
They want the money back, and he doesn't want to give them the money back.
Exactly.
For obvious reasons.
Of course.
And he's suing them for getting him arrested.
So he's found not
Because they were
guilty.
behind, the argument's going to be that the insurance company, through their investigators, basically pumped information into the prosecutor's office, to the investigator, that only pointed to him, that ignored everything about her, because they wanted him to get arrested, convicted, and ultimately they would get their money
So
back.
he's found not guilty?
Not guilty.
Okay, there you go. We
Not
didn't know.
guilty. If
There
I
you
was
go.
the if I was the judge on this case, And if it's a non-jury trial, I would have no difficulty whatsoever in determining this case. None whatsoever.
Is the civil court case going right now?
Still going.
Okay. Are you involved with that?
I don't think I should comment.
Don't comment. Okay, well, I'm asking. I shouldn't ask. Okay, it's just like Donald Trump. Don't ask, don't tell. Don't say anything.
Is that what he said?
I don't know what he said. Who cares? I'm sick of hearing what he says. But that's my own personal opinion, Judge. I know that you don't have a political viewpoint.
I don't. I made it very obvious from the first time that we got together that
I can make them.
I don't make any political. I'm not political. Even as a bench officer, I would express my personal opinions about anything.
You should.
Even though I'm not sitting in criminal cases or anything else, and we don't see cases like this in small claims court. So, whatever that is,
you shouldn't have. You shouldn't have to do that. You shouldn't do that. You shouldn't.
No,
you should be.
I'm going to think about all this
apolitical.
because I'm on the bench tomorrow. So.
Oh, you are?
I am.
In Ventura?
In Ventura, yes, I am.
I'd go in there and sit down and watch you work when I'm playing golf.
You can make a lot of noise. You can make some noise, and we have the real bailiff throw you out.
Oh, would you have him throw me out? Maybe I'll come down here.
I want to be there for that.
And
I want to be there.
By the way, in our court, we use one of the criminal courts, and we have a cage. And so I always say to the people, if you misbehave, this guy over here is going to put you to sit over there.
In the cage.
In the cage.
Gary, you'll be in the cage. I have a funny feeling.
I like cages sometimes.
Oh, boy.
Well,
I'm going to touch that one.
you know.
All right, well.
We got to go.
Have you been restored and brought back to your parents or anything, taking you out of the cage? Or you're not one of those kids that they took away?
No, I'm talking about being with. It's a sexual thing, Judge. Don't worry about
that's
it.
Right. That's what you were doing for like 18 years. I got
I'm not
it.
talking about cops and robbers and cages for my parents.
And we're going to introduce you to Stormy Daniels when this is all over.
I can't wait.
Oh, didn't you interview her one time?
I interviewed her a few times. I'm trying to find the friggin' tape. I'm going through all my old tapes, so I'm looking for it. I'm looking for it right now as we speak.
I hope you find it.
I hope so too.
Go on
Probably
cable
really
and just press porno.
Oh, boy.
We got to go, Judge. All right.
Okay, well, we'll see you next week.
All right. It is for the people of Judge Herb Dodell. If you want to get his book, From the Trench to the Bench, you can go to Amazon.com. Check out his YouTube videos, Judge Herb Dodell. He's got plenty of YouTube videos. And I think that JudgeHerbDodell.us is his website. All right,
And
you guys.
thanks to Carl for being
Carl
our guest
Evans,
today.
yes. Going to create a TV show for the judge, make us all rich. All right, we'll be back next week.
KCAA Loma Linda, 1050 AM, 106.5 FM, and now 102.3 FM.
Do you feel tired in the middle of the day? How about a boost? O2 for You helps boost your energy just when you feel you've had enough. This portable oxygen canister is simple to use. Just inhale, hold for a second, then exhale. Benefits include hangover relief, reduced stress and fatigue, and drives endurance at the gym and in intimate settings, if you know what I mean. For you smokers, you know who you are. O2 for You can possibly help you quit smoking. O2 for You also enhances focus for seniors. O2 for You is featured in the newly released major motion picture Limelight, starring Paul Vandervoort, Jenna Jameson, and Jonathan Lipnicki. Stream Limelight on Google Play, Amazon, and iTunes. Call 877-720-7553. That's 877-720-7553, 877-720-7553 right now, or visit them at buyo2foryou.com. That's BUYO, the number 2, the number 4, the letter U.com. Do you have any questions about legal issues? Have you ever been stopped by a police officer and issued a ticket that you're scared to deal with? Have you ever been in trouble with the law and don't know what to do? Do you have a will or power of attorney question? Is your home being foreclosed upon and you don't know where to turn? Maybe you were given a contract that you don't understand. For freedom and a worry-free solution, call for Legal Shield today at 213-245-1305. It's that simple. You will have access to high-quality law firms that will fight for you for less than $1 a day. Peace of mind is just a call away. That's for Legal Shield. Call 213-245-1305 or visit us at nocourt.us. It's justice for all and not justice for some. So, you want to be in show business. Do people tell you that you're really funny, you have a great personality, and you should have your own talk show? Many of us have been told that, but we don't know how to get started. It's easier than you think. Let the pros at Cali Vegas give you a free talent evaluation. Call 949-445-1119 and learn how quickly you can create, produce, and host your very own talk show. Imagine not having to sit in traffic every day, commuting back and forth to the same old boring job. Get started in television or radio today with your free talent evaluation from Cali Vegas. Call 949-445-1119 or visit them online at calivegas.com. Make your dream come true today and create your new career and learn how to become a television or radio star with the help of Cali Vegas. 949-445-1119. Call now. Are you a small business owner or pursuing the dream of starting your own company? Do you know where to start or how to grow that existing business? The American Business Trust Company has the answers you need. The American Business Trust Company can help you with startup capital, business strategy, sales and marketing, and establishing your company with a physical location or on the internet. You decide. You bring the idea, the American Business Trust Company can help with the rest. For a free evaluation, you may visit them online at abtrustco.com. That's abtrustco.com, or call them at 657-600-1876. That's the American Business Trust Company, 657-600-1876. Call them today. They can help your business right away. Do you have any questions about legal issues? Have you ever been stopped by a police officer and issued a ticket that you're scared to deal with? Have you ever been in trouble with the law and don't know what to do? Do you have a will or power of attorney question? Is your home being foreclosed upon and you don't know where to turn? Maybe you were given a contract that you don't understand. For freedom and a worry-free solution, call for Legal Shield today at 213-245-1305. It's that simple. You will have access to high-quality law firms that will fight for you for less than $1 a day. Peace of mind is just a call away. That's for Legal Shield. Call 213-245-1305 or visit us at nocourt.us. It's justice for all and not justice for some. So, you want to be in show business?